Yep, orientation is locked forever. I'm never able to change that on this phone at least. So I just want to talk about how Judge Owsley seems to have lied to me about who can use or which judges are allowed to allow recordings in the courtroom. He said that the Supreme Court does not allow him to record in the courtrooms. And so I asked ChatGPT that specifically. Is there any rules, laws, courtroom rules, or anything like that that says that Judge Owsley is not permitted to even consider allowing me to record in the courtroom? And there's just nothing. I mean, particularly for Louisiana. Louisiana does not have blanket rule prohibiting judges from recording in the courtroom. Okay, prohibiting judges, okay. The state has rules and guidelines that address the use of recording devices during recording proceedings. Okay. These rules generally give judges discretion over whether recordings can take place, both by the media, which would be me, and court personnel. So I'm not understanding where he's coming from, and I didn't make the proper arguments in court, and largely because I didn't have ChatGPT to address his issues. Because I mean, I would ask him to. I would. Okay, I'm not going to ask anything from the court. I'm going to make my demands. Okay, I have to make my best argument and make my demands, and that is, Judge Owsley, okay, you may have reasons. Wait, okay, discovery. I've been looking up discovery too. I got a case. I got a court date tomorrow in West Milwaukee at 5:45 p.m. And I'm not exactly sure where I'll be able to set up for that. I mean, I got this empty room right now. Okay, but can I get it tomorrow at 5:45? This is like a first come, first serve room. So you say, Judge Owsley, that the reasons only that you cannot record, that you cannot allow me to record in the courtroom are just simply because the Supreme Court says that you're not allowed to allow people to record. And that's Judge Owsley choosing like what other people say and not making his own decisions. He chose the excuse that the Supreme Court said he can't record in the courtroom, and he also said that the lady with the dog at the public defender's office, you know, they're also a doggy daycare at the public defender's office in Natchitoches. They decide, their computer decides whether I'm approved for a free lawyer or not. That's out of his hands as well. There's so much out of Judge Owsley's hands because he's just a lowly city judge. But he could throw me in jail for 30 days without, and then blame it on you guys. You're the problem. Blame it on you guys and throw me in jail for 30 days. The reasons judges may prohibit recording, okay, and he didn't mention any of these. All right, and he can use ChatGPT just like anybody else. Fair trial concerns. Judges may prohibit recording to avoid distractions, protect the integrity of the proceedings, and prevent undue influence on witnesses or jurors. Okay, but he didn't say that. Mugshots are cruel and unusual. I find that hard to believe. They must have really twisted their arguments for that. Privacy and safety. In cases involving sensitive matters, such as those involving minors or victims of certain crimes. Judges may restrict recording to protect the privacy and safety of those involved. I don't see how that has anything to do with my case, my active case out of Natchitoches, where my next hearing is in October 17th. Court rules and procedures. Many courts have specific rules that limit or outright ban recording devices in the courtroom to maintain order and respect for the legal process. And that's, I think, what he's relying on is this court that has specific rules. Well, that's what I'm trying to get to the bottom of, because that should be something I could be able to see. All right, what does it say exactly? Where is it in this rule? Because there's a bunch of judges who got together, and they should be elected, who said that recordings are outright banned. Okay. I also have reasons a judge may allow recording. Let's see, skip to Louisiana law and case law. Louisiana Code of Civil Procedure, Article 191. Allows judges discretion to manage their courtrooms, including whether to permit recording. Let's see, different courts may have specific rules. So he's not mentioning any local recording rules. He's just kind of saying it's a Supreme Court decision. But Louisiana does not have a blanket rule prohibiting judges from recording in the courtroom. Okay, now let me just re-ask that question, because this answer is saying that prohibiting judges. How about prohibiting defendants? Okay, does Louisiana have any rules prohibiting? Because you know how ChatGPT likes to hallucinate. Any rules, and I'm using the ChatGPT 4.0, you pay $20 a month for, so this is not 3.5. Have any rules prohibiting defendants from recording in the courtroom? Okay. All right, any kind of rules, and I just kind of said that. Oh, yes, okay. Okay, let's get into this then. Louisiana has rules and policies that prohibit defendants and the public from recording court proceedings without prior approval. The authority to allow or deny recording in the courtroom typically rests with the presiding judge. Okay, so, and unauthorized recording by defendants is usually not permitted. So it comes down to the judge. It doesn't come down to the Supreme Court. All right, don't be passing the buck, because that's what Judge Owsley made a mistake with. He kept passing the buck, saying that, oh, it's the other guy's decision. Oh, it's that guy's decision. Oh, if they don't want that done, then it's out of my hands. And he kept saying that, passing the buck, until the Third Circuit Court of Appeals calls him out on it and says, no, you're the one who needs to make a record of whether or not this defendant is allowed a free lawyer or not. Okay, he was passing the blame so much, and that was not making for a good record. When he doesn't make decisions, when he doesn't make the proper decisions as a part of procedure, then he has gaps in his record. So, yes, it's something to talk about. It's something to make a record about. Let's see. Courts also aimed at maintaining courtroom decorum and integrity. I don't see how even a voice recorder, just a voice recorder, not even a video, okay? Not even a video camera. You're just recording audio, and you could have that in a pocket. You know, I don't see how that's a problem. It's like only voice. and something that you could refer to. I don't need to be getting video. I can understand. Let me just go further with this. Use of electronic, and that's a part of electronic devices, including audio and video recording. They have rules. Okay, does ChatGPT go into those rules? Let me just there's local rules, approval required, strict conditions. Are permitted, specific, such as aiding in it might only be permitted, even when allowed. Recording by a defendant is typically subject to strict conditions. For example, it might only be permitted for specific purposes, such as aiding in the defense, okay, and may require supervision by court personnel. Aiding in the defense. See, they did so much to stifle my defense so they could get to this conviction. I can't write very fast, and to be able to record allows me to be able to make voice notes. This is something that students do in school. It just makes sense to record a lecture now. When I was in school, we didn't really have those. We couldn't really record anything. It was all entirely notes. But now the technology's improved a whole lot. Why be banning that new technology? It's a learning aid. It's something that people who have a disability, a handicap disability, could really make use of. And the judge just wants to cripple a disabled person even more by holding back on these devices. It totally makes sense. You should be able to have a recorder in your pocket, but my voice recorder is sitting in the evidence room in Natchitoches as I speak, still gathering dust. It's been there since May or March. Let's see, January, February, March, April 2022. It's my voice recorder has been in the evidence locker since April of 2022. So that's over 2 years now, just because I had it in my pocket. Louisiana Code of Civil Procedure 191. This article provides judges with the broad authority to regulate court proceeding. Okay, that's specific court rules. What about Louisiana Supreme Court guidelines? The Supreme Court has guidelines governing media coverage, but these also imply that unauthorized recording by private parties, including defendants, is not allowed without express permission. Okay. I think I want to ask specifically, what does the Louisiana Supreme Court say? Consequences, penalties is contempt of courts, may negatively affect your case. Okay, specifically, what are the Louisiana Supreme Court guidelines? Specifically, what are the Louisiana court guidelines? And that's all I need to ask, because ChatGPT knows what we're talking about right now. I don't need to go into any more detail than that. So all I have to do is just say specifically, what are the Louisiana court guidelines? And I expect a very specific answer here. Okay, and there's the answer. Louisiana courts guidelines regarding recordings in the courtroom are primarily outlined in the rules adopted by the Louisiana Supreme Court and local court rules. While there is no single comprehensive statewide rule explicitly detailing every aspect of recording in courtrooms, there are several key rules and provisions that address when and how recordings can be made. Here are the most relevant guidelines. Okay, and there's a bunch. Okay. Louisiana Supreme Court Rule XV, broadcasting, televising, and recording of court proceedings. Okay, I would be a part of and recording of court proceedings, I guess, for audio. This rule governs media access to courtrooms and outlines the circumstances under which broadcasting, televising, or recording of court proceedings may be permitted. Under this rule, recording or broadcasting proceedings requires prior approval from the judge. The judge must ensure that such activities do not distract participants when it's in your pocket, impede justice when it's in your pocket, or prejudice the parties while it's in your pocket. I don't see the logic in how something in your pocket is going to do any of that. Okay? Specific conditions can be imposed by the judge, such as restricting the location and movement of cameras and other recording devices. It's in your pocket. What else do you need? You can have a voice recorder in your pocket, and it doesn't do anything. You forget about it. I forget about it. They don't even know about it. They'll be kind of aware of it, and then they'll forget about it. Everybody will forget about the voice recorder in the pocket. Okay, that's the amazing thing about how they're pushing for like these. They're hallucinating. The court hallucinates problems that aren't there over simple things they can't see until they strip search you. They strip search you and then find it, and then suddenly they backpedal and say, oh, that's a harmful thing you got there. You get a court reporter. You could do court reporter stuff in Kentucky, but don't bother with Louisiana. They won't. You just be paying another person. You already pay the clerk of court for the transcripts, so they don't even allow private party court reporters in Louisiana. They have no jobs. It's the state paying them pretty much, and it's through the clerk of courts. But not in Kentucky. Kentucky has privatized court reporters. Let's see. We got another rule. Okay, uniform rules for Louisiana Court of Appeals. Rule 2-12.12. Television and radio broadcasting. Well, that has nothing to do with me. I'm going to ask specifically about a voice recorder in the pocket. Local court rules. Each district or parish court in Louisiana may have its own set of local rules governing recording in courtrooms. While these rules often vary, they generally reflect the principles established by the Louisiana Supreme Court, placing the decision to allow recording at the judge's discretion. And they reflect the principles established by the Louisiana Supreme Court. The Louisiana Supreme Court principles are to allow the decisions over recording to be at the judge's discretion. So that's something I would explain for me. I would explain to Judge Owsley that I didn't have this tool to explain it to him. I only made a couple of arguments that didn't really have anything to do with this. Courtroom decorum. Oh, decorum. To make it look like it's professional. You want to look professional. Many local court rules emphasize maintaining decorum and order, which often results in prohibitions or restrictions on the use of recording devices by the public, including defendants. Well, once again, a voice recorder in the pocket. What's the problem? Yeah, I don't know about using laptops in the courts. I wasn't allowed. You're in Kentucky, in McCracken County, Kentucky. You can't turn on a laptop until you're at the podium, because the guards are giving me a hard time. But then I look over and I see the lawyers typing away on their laptops happily, while I have to sit with my computers in my bags until I can get to the podium and then ask Judge Jones for permission to turn it on. So I can't even look at my notes before going up to to that podium, and that really, I mean, Judge Jones really makes it difficult to defend yourself with that rule. Let's see. Judges have broad authority to permit or prohibit recordings in the courtroom, even if allowed. The judge may impose specific conditions to ensure that the proceedings are not disrupted. How is it possible that the proceedings get disrupted with a voice recorder in your pocket, like your shirt pockets? How do you see any problem with that? Well, I mean, you'd just be hallucinating phantom problems. Written request, whatever, restrictions. Yeah, minimize interference. They want to make sure the use of audio recording devices minimize the interference with the proceedings. You won't even know it's there. That's the thing. That's what's amazing. When I got arrested after I got convicted and sent off to jail for 30 days, the first thing that the city marshal goes for was my shirt pocket to pull out my voice recorder and said, "Judge Owsley, stop, look at this." And suddenly it was like I smuggled in a knife or something. Unauthorized recordings. Recording without the court's permission is generally prohibited. Unauthorized use of recording devices could lead to sanctions. See, it's amazing. They take away your pens and paper. You're not allowed any pens or paper in jail. And you're not allowed to even use a voice recorder in court. They want to make it so secretive, but it's not secretive. That's the thing. It's very public. Yet nobody is standing up for themselves. It's not privileged information. And in fact, they've gotten so secretive with it that in the past cases with Judge Owsley, you can't even find the cases. And these are trials. They didn't keep records of some certain trials because they were able to get away with suppressing your ability to make records yourself. So what harm? Let me ask ChatGPT. Pretend you are a judge, and what harm do you see with the defendant using a voice recorder in their pocket? All right, so we've gone over the rules multiple times here in different ways. It's not exactly clear. They just keep saying it's up to the judge's discretion. Maybe Judge ChatGPT can figure this out. Judge ChatGPT will be the judge here. So let's see what the decision is. I should have hit that already. As a judge, the primary concerns with a defendant using a voice recorder in their pocket during a trial or hearing revolve around ensuring a fair trial, maintaining courtroom order, and upholding the integrity of the legal process. I don't see any. Here are the potential harms or issues that could arise. All right, risk of tampering or misuse. A defendant using a personal recorder could selectively record parts of the proceeding, potentially manipulating the context of statements made in the courtroom. This could lead to the creation of misleading or inaccurate records. Oh, what? Okay, I think that's a weak argument. I'll continue, but I think it's got to be made clear that also the judge has their own recording as well. And it's making it sound like that's not even an argument. Okay? Like, I'm the court reporter now. I'm not saying I'm the court reporter. I'm saying I'm the defendant. So ChatGPT is a little confused there. All right. And yeah, I think the chat died. So it happened. The chat dies after 20 minutes or so, and I stopped seeing any new messages. That happens every time on this. Let's see. I don't know how to reset it either. Maybe, I don't think that's going to do anything. Yeah. Let's see. Editing. Oh, wait, no, chat didn't die. Okay, so editing and distribution. There is a risk that the recording could be edited or disseminated in a way that could prejudice the case, influence public opinion, or impact witnesses and jurors outside of the court. And that's where the restriction should happen, is when if it's made public. But I mean, for your personal use, to be able to refer back to your notes is pretty important. I mean, they say they can get the transcripts to you, but they don't get them to you in record pace. You got to wait some time, and it takes away from your defense. And when it's so much easier to make your own recording for everything. I record cops, record the courts. It's really, it's amazing how the judges, a lot of judges have turned against it. And it's like, I mean, you would think there should be a shift in the paradigm on which judges get elected into their positions. All right, you would think it should be more likely that judges who are allowing cameras to be more likely to be elected into their positions than judges who are denying courtroom, denying recording. You would think, I mean, at this point in our lives, with recording devices everywhere, you'd think there might be a shift in the influence on elections over recording in the courtroom. I mean, to me, that's a big political issue right there. That's like the only question you need to ask the judge. Do you allow cameras in the courtroom or do you not? You know, it's not like, are you a Republican or Democrat? I don't know if that's so important. I want to ask, do you allow recordings or not? That would be, well, for me personally, that would be a political point right there. And they can go into detail about what their thinking is on that. Let's see, witness privacy, a violation of privacy, sensitive testimony, especially from vulnerable witnesses with minors, attorney-client privilege, disruption. No, I don't see disruption of a courtroom as a problem. Obstruction of justice. In some cases, a recording device could be seen as an attempt to gather information for purposes outside of the legal process, such as planning, intimidation, or retaliation against witnesses. Okay, and that depends on the severity of the case. I mean, failure to ID, I don't see how there should be any reason to restrict recording for that. I mean, intimidation or retaliation, that's really creating a wide latitude on the imagination about how ugly the situation can get over recording. What kind of information can you pick up from a courtroom hearing, which is public anyway, that could allow you to intimidate or retaliate against a witness? Once the trial's over, they're no longer a witness, and that's it. So they're talking. This ChatGPT is talking about before the trial, because they're a witness before the trial, and then they don't have that status after the trial. Conflicting records. Yeah, I don't know about that. Impartial records. Judge Owsley doesn't record in some of his cases. So you recording yourself could be the only audio recording that you got. And that's better than nothing. All right? Having partial recordings is better than having no recordings. Okay, there's a there's a benefit there. What about I should be asking ChatGPT, what if the court fails to record themselves, but you have it? What do you do then? Oh, is the judge gonna find you in contempt of court, but also not see any problem with themselves failing to record? It's quite an amazing issue there going on with that. When the judges don't record, and if the judge, imagine getting in a situation like that, how would that turn out? The judge fails to record, but you were able to record a hearing or the trial. What do you do? There could be a real conundrum if somebody gets in a situation like that. The court must maintain control over the recording process. Yeah, their own recording process. Private recordings can compromise this control. I don't know about that. Setting a precedent, allowing one defendant to use a personal recorder could set a precedent leading to requests from other parties. Oh, what a problem that could be. What about setting precedent with Judge Owsley failing to record his court hearings and even trials? He's setting precedent and just not recording multiple trials. Violation of court rules. Most courts have established rules regarding court recording devices to ensure the fairness and decorum. Permitting an exception for a defendant undermines these rules. Prejudice to the jury. If the existence of a private recording becomes known, it could raise concerns among jurors about what is being recorded and for what purpose. This might distract them or bias them against the defendant. So if the jury knows that you're recording, they could be distracted by a little voice recorder in your pockets. Knowing that a private recording is being made could make witnesses reluctant to testify or alter the contents. That's pretty much like saying knowing that there's people sitting in the observation area listening to what they're saying, listening to their testimony. It's like if anybody hears it, one or two people hear your testimony, it might make you hesitant to testify. A voice recorder and the defendant might seem harmless on the surface. It poses significant risk to the integrity, order, and fairness of the legal process. Yeah, those are some arguments, but man, those are just. Let's see. What about? What if you're okay? Pretend you are a judge, and you failed to record a trial. Okay. You are a judge who's failed to record a trial. Record as in so there are no transcripts. All right. Let's see. How do you say what? I could be like, what do you do? You're a judge, you failed to record a trial. You are Judge Owsley, and you failed to record a trial. Pretty much, it's probably every Louisiana judge, though, pretty much. At some point, has failed to record a trial. There are no transcripts. How can that mistake be remedied? Okay, maybe something like that. What is the remedy for that mistake? Maybe how about that? What is the remedy for that mistake? Is the remedy for that mistake? I'll just keep it kind of open-ended for that. If a judge fails to ensure that a trial is properly recorded, resulting in no transcripts, this situation could present significant legal challenges. The absence of a trial record can impact the defendant's right to a fair appeal and the integrity of the judicial process. The integrity, okay? Pretty much calling them liars. That's why I call him harmful. Harmful Judge Owsley. But he's also a liar. Here are the potential remedies that can be considered. Reconstruction of the record. Oh, that's right, reconstruction. I remember reading something like that. One potential remedy is to attempt to reconstruct the trial record through a stipulated statement. This would involve the judge, attorneys, other court participants, witnesses, working together to create an agreed upon summary of what transpired during the trial. And then they all get together and like, okay, this person said that. Are you happy with, Judge, are you happy with me recollecting it in this way? Okay, is that something that'll make you happy? All right, by memory and notes, the attorneys for both sides can submit their notes and recollections of the proceedings. Witnesses and the judge may also contribute to recreating what occurred. However, this method is often imperfect and may lead to dispute over the accuracy. And see, that's something that maybe my lawyer could have asked, my former lawyer in Louisiana. He could have, if when Judge Owsley came back, or Shanita came back and said there are no records of that trial, then my lawyer could have been like, okay, can you reconstruct the record? Okay, let's do a follow-up on that. Okay, we're asking for actual records, public records here of a real significant, of a significant kind of a trial. All right, and you didn't make any recording. Then the next step is to make a reconstruction, or you can motion for a new trial. So then, I mean, can the public? I mean, they'll probably say, I as say my lawyer who asked for all the records of previous defendants before me. He asked for the trial transcripts of former trials, and Judge Owsley comes back and says he has none. The best my lawyer could do is ask for a reconstruction of the record. He cannot ask for a new trial because we're third parties here, so we can't just ask for that. My lawyer can't appeal on the basis of judicial error because I wasn't the defendant in those trials. And there's no post-conviction relief, impact on the defendant's rights. Yeah, so if you're just asking to see those records, if you weren't the defendant, then the best you could do is ask for a reconstruction. So as a defendant, and Judge Owsley made sure that he was recording all my hearings in trial. When it was like the case, the trial right before me, I think they didn't have a recording of that, and then suddenly miraculously they start having all the recordings for all my hearings and stuff. They were very focused on recording my hearings and having multiple hearings too. Got to make sure that I have the report to the court multiple times. Make sure it's all recorded, all just for me. Where previous defendants, they were losing transcripts. All right, post-conviction relief. All right, so impact. I want to see. It's something where it should just be thrown out. Judicial oversight and corrective measures. The judge may be subject to judicial oversight for failing to ensure the proper recording of the trial. Courts generally have procedures and protocol to prevent such situations and, like have more than one recording device. And judges may be required to take corrective actions to prevent recurrence. Court order and policies. Moving forward, courts may implement or reinforce policies that ensure all proceedings are recorded. Okay. The judge may be subject to judicial oversight. Okay. Let's see. All right. What do you mean by judicial oversight? Let me ask that. What is that? What do you mean by judicial oversight, and make it specifically for judge? Well, I can't. Just what do you mean by judicial oversight? Okay. What does that mean? It refers to the mechanisms and processes that ensure judges adhere to the law. Okay. Here's how judicial oversight can operate, especially in situations like failing to record a trial. Court policies. Courts have internal policies that outline procedures, requirements, including the recording. Okay. Failure to adhere to the procedures can prompt internal reviews and corrective action. Okay. Regular audits. The Natchitoches City Court needs more audits if they're getting any at all. And reviews. Let's see. Judicial Conduct Commission. Because I question Judge Owsley's integrity. He's making all kinds of mistakes on many different levels in the process. Judicial Conduct Commission or board responsible for investigating complaints of judicial misconduct. If a judge fails to follow required procedures, such as ensuring a trial is recorded, a complaint can be filed with the commission, and that commission is a Judicial Conduct Commission or board. All right, so you just throw a complaint at them. Let's see, a commission can investigate the judge's actions, impose disciplinary measures ranging from a warning to more severe actions like suspension or removal from the bench, depending on the severity of the misconduct. Well, public accountability, how about that? Court proceedings are generally public, allowing for a level of transparency and scrutiny. Members of the public, including the media, can report judicial action that appear to violate procedural norms, which can lead to formal complaints and investigations. Okay, somebody can sit in the observation area and report if they see something that doesn't seem right. But I mean, who would know in the observation area whether a court proceeding is being recorded or not? Okay, this is something that you find out afterward. You don't find out while the proceeding is happening in real time. Parties involved in a trial, such as defendants and attorneys, can raise concerns about judicial conduct. An investigation or appeal. Okay. All right. So it's just incredible to me the hypocrisy where I face contempt of court over a voice recorder, and there's nothing that Judge Owsley faces for failing to record trials. It just doesn't. It's not fair. That's That's the difference between being an elected person and just a regular citizen. Okay. Well, I guess, yeah, that's a problem. And I'm having problems with keeping with being able to make a good record with Natchitoches, and I'm having I'm having a problem with West Milwaukee tomorrow. West Milwaukee it has a big problem with recording in the courtroom, but the big difference between West Milwaukee, Wisconsin, and Natchitoches, Louisiana, is that Natchitoches is just, I mean, for me at least, they're banning all Zoom hearings and anything that related to Zoom, even though they're holding trials over Zoom before me. And West Milwaukee insists on Zoom. They say do not come to the courtroom. So it's right now I got these two active cases, West Milwaukee and Natchitoches, and they're just, I mean, they couldn't be more completely opposite from each other. And they both don't want me recording, but they're both approaching it in different ways. And I mean, they're pretty much the same charges, the same kind of charges. It's just, I mean, I faced 30 days I spent 26 days in jail in Louisiana, and I'm facing $600 fine for tomorrow. And I don't even know what to expect for what Judge Sanfilippo is going to say or do tomorrow. I mean, I'm in the discovery phase, and that's it. I think I made okay. I think I'm keeping some notes with that West Milwaukee hearing. Let's see. I'm in the phase. Let's see. I'm still in the preliminary examination part. Let's see. Preliminary. It's not even. I'm not even in pre-trial yet with West Milwaukee, and it's been 3 months. It's been over 3 months now. I'm still in the preliminary, just trying to get evidence. I'm just asking for evidence. I'll be doing this over Zoom tomorrow somewhere, maybe in this room. Yeah, I'm arguing for evidence, and there's two levels to argue for it. The first is just simply I have a right to see it. Okay, under the Brady rule, and it's a part of the decorum. Let's see. And then also, one of my first questions is going to be, Judge, have you found probable cause to make this case move forward? Okay, the case should not proceed without a determination that there is a sufficient evidence to support the charges. See, in Natchitoches, Louisiana, Judge Owsley has found probable cause within 5 hours. Doesn't take him long. He wrote out a warrant for my arrest. I was arrested at 1. He had his 48-hour arrest warrant at 5 while I was sitting in jail. And he found probable cause based on the police reports. I don't even know if he saw the body cam. But that was quick. But in Wisconsin, it's not clear to me that the judge even has found probable cause yet. She didn't find probable cause within 4 hours like Judge Owsley did. And that's not exactly. But I'm not in. I was never taken to jail. I was taken to the police station and in the intake room, but not to jail. Judge Owsley needed to find probable cause because I was in jail, but I guess Judge Sanfilippo didn't need to because I had no bail. I wasn't thrown in jail, so there's that. Okay, well, I'm going to stop this. Library's closing soon, so I'm gonna stop this here. So that's all I have to say.